Well, good afternoon and welcome. We are so excited to have you join us today as we discuss insights and strategies for navigating the complexities of estate planning. And this is a very important topic, one that we have talked with many of you about. So, before I introduce our guest, please know that this webinar is being recorded. So, for any reason, if you need to drop, we will post the replay on our website. And again, our website is evansmay.com. I'd also like to thank everyone who submitted questions in advance of the webinar. So if you have any questions for Rebecca during the webinar, please enter them using the Q&A feature. And you can find this by hovering over the bottom of your screen. Please note that the questions you submit are anonymous unless you elect to submit them so that others can see your question. And we'll make sure we'll have some time at the end of Rebecca's presentation to address all your questions. That's what this is all about. So let's talk about our esteemed speaker and guest. Rebecca Geyer is an estate planning attorney. She owns her own firm, Rebecca Geyer and Associates, and she concentrates in estate planning, estate and trust administration, elder law, tax planning, and business services. So we have worked with Rebecca for a number of years. We have many clients who have used her, and I have always had very positive feedback. So there are many accolades I could share with you about Rebecca, which I'm not going to go through all of them, but just a few. She is a fellow of the American College of Trust and Estate Counsel. She previously served as the past chair of the Indiana chapter. She is an adjunct professor of elder law at IU's McKinney School of Law. She served as the president of the Indianapolis Bar Association, Indianapolis Bar Foundation, and she's consistently been ranked as super lawyer, top 10 attorney in Indiana. And last year, Indianapolis Business Journal ranked her as one of the top 250 most influential business leaders in our state of Indiana. So we're super thankful and grateful she's taken time to share her insights and expertise. So without further ado, Rebecca, I'll turn it over to you.
Thank you so much, Lizzie. I appreciate the warm welcome. It's a pleasure for me to be here this afternoon. We are going to get into some estate planning basics. I want to make sure everybody has some really valuable information. As part of today's presentation, I thought it would be easiest to share a PowerPoint with you. So I'm actually going to be sharing my screen so you can follow along as I present. I'm going to be beginning today actually not discussing documents you need to have in place, but some practical things that you can think about. We're going to talk a little bit about proactive planning. We'll then get into what estate planning actually means and what the components of estate planning is. We'll talk about more difficult things like trying to choose people to serve in certain roles in your estate planning, also the current state of estate tax and laws in Indiana and in the federal government. And then we'll talk about different options that are available to help you plan. So that's a little bit of a roadmap of where we'll be going. I'm going to take just a minute to share my screen. Good. So I put together and I titled this program, Understanding the Basics to Help You Sleep at Night. I have a lot of people who come to me and they tell me, oh, thank goodness, now that I got this in place, I can sleep better. So I thought it was an aptly named title. We are going to start, as I mentioned, by talking about some practical considerations that you can do that do not require the assistance of someone like me. They're just some things that you can put together so that in the event of an emergency, your family members are best equipped to be of assistance to you. Lots of times people take the time to put things together like their legal documents, but the things I'm about to share with you are practical suggestions that you can do. And by having these things in place, you can really aid your loved ones in the event of any sort of emergency or death, because often people would not know where to turn if you don't have this information gathered for them. So we're going to begin by talking about proactive planning. And oftentimes people think, gosh, what do my loved ones need to know or have in place in the event they're going to assist me? So one of the things that I often recommend is for clients to take a few minutes and consider as part of the planning process, gathering a bit of information. And I like to look at mine on an annual basis to see if there have been any changes or updates that I need to put in place. I find not just in my own life, but for a lot of my clients who, especially those who are married, there is often one spouse who primarily works with the finances. And so it's really important for you to gather this information in case something happens to that person, because whether it's a surviving spouse or a child or another friend or family member who's going to take over, it's really helpful to have these tools at the ready so they can properly assist you. So the first thing I put on my list is a copy of your health insurance card. Most of us are out and about and we take care of our own medical needs, and we don't think about the fact that our loved ones might need a copy of our health insurance cards in the event something happens. But if you were in a car accident or required any sort of long-term medical care, your health insurance cards are going to be needed, and they don't automatically transfer the information from setting to setting. So it is a good idea to make sure on an annual basis you make copies and keep these in a folder or in a computer file where your loved ones could easily access that information. I also recommend that people put together a list of medications that they take and for what purpose. There are really no true permanent medical records. There might be medical records if you see all of the same physicians in one medical group, but if you happen to see physicians in multiple hospital groups, your medical information is not going to transfer from one platform to another. So if you had an emergency, it's likely going to be required that you present medicine information or medication information to a medical provider at the time that you are seen. So it's important for your loved ones to have this in case of an emergency. I also recommend that people consider putting together a list of any doctors that they see, as well as specialists. So it could be your primary physician, or if you see a cardiologist or a neurologist, a counselor, whoever it may be, so that in the event of an emergency, your loved ones know who to contact. The next thing on my list for you to consider as we begin discussing estate planning is a list of online passwords or safe codes or safe deposit box keys and information. More and more these days, passwords are becoming the bane of my existence. I deal with them, of course, on a personal basis because we do so much online, but on a professional basis, if someone becomes incapacitated or passes away, oftentimes we need passwords in order to access that information. So more and more, I want to encourage you to consider making sure that someone has the ability to log onto your computer, to look in your browser for saved passwords. If you use a password manager like LastPass or OnePass, we want to make sure that someone has the password in order to access that information so that we can get the valuable data we need in order to assist you. So consider keeping a list or at least some starting place where password information can be found. You might even consider using a password convention, meaning you set up your passwords the same way, maybe not the same password, but maybe you use the same starting word and a different phrase at the end or numerical combination, but it might help someone guess the password if they're a family member. Monthly income and asset information. Oftentimes, I am, as an attorney, dealing with individuals who have suddenly become disabled, and we need information about what their monthly income may be. Luckily, if you work with Lizzie, she'd probably be able to tell you that information, but sometimes I have situations where people don't have access to that information. So if you can keep a list of what the source of the monthly income is and whether it's direct deposited or we should be on the lookout for a check, that's really helpful to allow someone to best assist you if a time comes when you cannot speak for yourself. The other thing I recommend is, of course, if you do have estate planning documents in place, which is something we're going to discuss today, it's really important that the individuals you've named in certain roles have copies of those documents, or at least know where to find them in the event of an emergency. You can have electronic copies of your estate planning. Those are valid just as much as an original. So it's okay to send scans of your documents to family members. If you're not comfortable sharing that information currently, letting them know who to contact, such as an attorney, or where you're storing your estate planning documents in the event of an emergency, can also be helpful. And also on my list is, of course, important advisors. Do you see an accountant, a financial advisor, an attorney? It's important for your loved ones to know who to contact in the event of an emergency. I did want to cover a couple of additional practical considerations. Unfortunately, for me personally, we had a number of parents in my life and in my husband's life who passed away last year. And I've been thinking more and more about the information that I convey to clients that I think that would be helpful that their loved ones have in advance. So, one of the things I put on the list for you to consider is writing a list of past achievements, memberships, degrees, or other information you would want potentially in an obituary. Many people, as they age, don't necessarily discuss with their loved ones key awards or memberships that they might have had that they were really proud of, but their children may only know a little snippet of what they did for that organization. And if you want to be remembered or you want to make sure donations go to a certain organization if something happens to you, it's helpful to have that information in advance. Another key thing, and I have some slides here to cover that, is more and more we're all doing more work and saving things on our smartphones. You may not be aware, but you can actually list a legacy contact on both an Android device and on an Apple iPhone device so that if something happens to you, people can gain access to the information you keep stored on your phone. That stored information might include passwords, it could include photos that your family members want to keep. It can include specific documents that you have saved in drives. And if no one has the ability to access that information, we may have to go to court in order to get an order to have Apple or Android through Google turn over that information. So if you take the step of having a legacy contact established to begin with, that can help avoid that process. Indiana also has provisions that you can include in your estate planning to give access to things like smartphones and other electronic devices, but it's much easier if you set up those contacts in advance. And lastly, because people don't these days keep as many address books, a lot of people don't have a little black address book like they did in years past. If you have a list of important contacts or people you would want notified in case something happens to you, that's a good idea to gather as well. I thought it might be helpful before we get into the nuts and bolts of the types of estate planning you should consider putting in place to let you know that as part of my slides, which I'll have Lizzie keep on hand in her office as well, in case you would like this information, I did put together for you how to set up a legacy contact for both an iPhone and an Android device. So if you're interested in getting that set up, you can easily follow the steps so that you know that someone you trust can be put in place to have access to the important information on your smartphone or tablet in case something happens to you. In my family, we joke, my husband's the only one who uses Android. The rest of us use Apple devices. So I actually had to make my son my legacy contact on my iPhone because my husband doesn't know how to use my Apple smartphone. All right, we're going to turn our attention now to the legal side of estate planning and what documents it is important to have in place. I found over the years when I tell people, oh, you're here to discuss estate planning, sometimes they don't really know what estate planning entails. So the first thing I wanted to mention is that estate planning is actually a whole group of laws that allow you to determine how you want assets you've accumulated during your lifetime to be distributed at the time of your death. There are many ways to approach that type of transaction. Sometimes that occurs via beneficiary designation or title. Other times it occurs through documents like wills or trusts. But all of those different choices make up the category of estate planning. Estate planning also allows people to appoint decision makers in the event they're still alive, but there is a period of time when they cannot act for themselves. Typically, that's going to be during a time of disability, usually if someone has a mental incapacity rather than a physical disability, although it could also be due to a physical limitation. One of the things that people are often shocked to find out is when we discuss estate planning, they assume if they have legal documents put in place, that those legal documents are going to control the disposition of all of their assets. And that is, in fact, a total myth. The first thing that is going to control how your assets pass at the time that you pass away is actually the title on your assets. So for example, if you own a bank account jointly with a spouse, that bank account is automatically going to pass to the other spouse at the time that you pass away. Or if you add a child onto your bank account as a matter of convenience, if they're a joint owner, they're going to be entitled to the funds on that account at the time that you pass away because title is going to control. The next thing that is going to control is a beneficiary designation. There are lots and lots of assets that you could own that could potentially pass by beneficiary designation. The most common actually are retirement accounts. Most of us have some form of retirement account, such as a 401k or an IRA, a Roth IRA. Retirement accounts, life insurance policies, and annuities all pass by beneficiary designation. So if you have a specific beneficiary listed, they're going to be entitled to the proceeds on that account, even if the will that you have or the trust that you have in place directs a different disposition of other assets. So I met with a couple just the other day, and they were very concerned about their child receiving money in a lump sum, but their child was the contingent beneficiary on their retirement accounts and insurance policies, and they didn't realize that that meant he would receive the funds in a lump sum. Other assets that you own, you could potentially also have passed by beneficiary designation if you have added a TOD, which stands for transfer on death, or POD, payable on death designation. You can do that on things like brokerage accounts, bank accounts, even your real estate or vehicle can pass by a transfer on death or payable on death designation. Those sorts of designations are going to control over any estate planning documents you have in place. So it's really important when you think about your estate planning that you realize that beneficiary designations and title will control first, because we not only want to put documents in place, we want to make sure that your assets are properly coordinated with your planning so that there are no surprises if something happens to you. We want everything to work the way you intend. So coordination of assets is really important, and we're going to talk also about family dynamics in a little bit, which can also come into play when making those decisions. So we're going to talk, as I mentioned before, about two types of documents that would be used to assist you. And the first one has to do with a time when you are alive, but if you were unable to handle financial affairs or make healthcare decisions on your own for a period of time. So under Indiana law, a person is typically considered disabled or incapacitated if they don't have the mental ability to handle financial affairs. That is typically determined by a physician or in a court of law if a guardianship proceeding were to take place. In Indiana, someone is also considered to be incapacitated or disabled if they are a minor. Any child under the age of 18 is considered to be incapacitated simply because they are a minor. Sometimes disability can involve physical effects as well. Typically, if someone still has their mental capacity, however, they're not going to be deemed disabled, even if they do suffer for something that might provide for a physical limitation, such as a difficulty in transferring or walking, or maybe vision loss over a period of time. Our goal in a situation where someone might be incapacitated is to make sure that they have the proper legal documents in place so that someone can assist them to handle financial transactions so that we don't have to go to court to have a guardian appointed. In the absence of the next document we're going to talk about, which is a power of attorney, what the law provides is that the only way that you can designate someone to assist you while you're alive and incapacitated in the absence of a valid power of attorney, if you're incapacitated, is to go to court and have a guardianship proceeding put in place. And that is very cumbersome and expensive. We do not want to go through that process if we can avoid it. The easiest way to avoid a guardianship is to put a document in place called a durable power of attorney. In my mind, a power of attorney is probably the most important document that you can have in place, even more important than a will or a trust, because no matter the size of your estate, almost everybody has at least one account. And it's really important that if there's a period of time when you cannot act for yourself to handle a financial transaction, that you have designated someone who could step in and pay bills and manage finances on your behalf so we don't have to go through that cumbersome guardianship proceeding. When you put a power of attorney in place, you are appointing someone to handle financial transactions, but you are not giving up any rights yourself. That is a common misconception. You're not taking away something from yourself by designating someone as your agent. You're simply ensuring that if a need arises when you want someone to assist to pay bills and handle transactions on your behalf, that they are legally designated in a document to do so, so that we don't need a court to make that appointment. I recommend that people not only put powers of attorney in place, but that they review them periodically. Powers of attorney can become stale. What I mean by that is if you did a power of attorney, say 20 years ago, and it has not been used, if you were to suddenly become incapacitated, a financial institution may want some sort of certification or some sort of statement indicating that that is still a valid power of attorney and that this is the individual you want to serve for you to ensure that your best interests are being handled. It's also really important to take a look at if you have a power of attorney in place and determine when it becomes effective. I meet with clients all the time, and many people think, oh, if I need assistance, I have a power of attorney in place. But when I look at the clause that deals with when it's effective, the effective date states that it's only effective if that individual becomes mentally incapacitated. That can sometimes pose a difficulty if someone does have any sort of physical ailments. I have lots of clients who, due to macular degeneration or limitations in mobility, can't get to the bank or handle financial transactions as easily as they once could. But the power of attorney that is only effective during a mental incapacity is not going to be valid to allow someone to assist them should the need arise. So taking a look at when your document becomes effective, perhaps giving you the ability to make it effective at any time as opposed to just in the event of a mental incapacity, is an important thing to review if you already have documents in place. Another very important thing to consider with estate planning are healthcare decisions. So you can have a separate document, separate from financial transactions, that allows you to name someone as a healthcare representative to make healthcare decisions for you if there's a time when you cannot make a decision for yourself. I want to make sure you have a conversation with your loved ones because many people assume that their loved ones know what their healthcare wishes are. But I have found over the 25 years that I've been practicing in this area that oftentimes there is a bit of a disconnect between what the individual client or patient wants and what the family member is willing to do or is comfortable doing, because sometimes children or spouses have difficulty letting go. And as a result, if you don't document your wishes, sometimes individuals end up having medical care they may not have otherwise wished to receive because they didn't properly document their wishes ahead of time. I highly recommend that you have a conversation with your family ahead of time and make sure they understand what your wishes are. And then you take a bit of time to make sure those wishes are documented in your healthcare document. The other thing to definitely consider is family dynamics. There are no perfect families, I can tell you for sure. Everybody has some issue that sometimes arises. Many times people will come to me and they don't want to offend any of their children. And so they say, oh, just put all of my children on as my healthcare representative. Well, if your children don't get along well, or they don't speak to each other, or one of them is incapable of making a decision or dealing with these issues, they may not be a good choice to serve in this particular capacity. So it's really important to account for family members. You can, even under Indiana law, exclude certain people from making decisions or serving as a potential decision maker, which is something that does come up every once in a while. People might have had an experience where someone was, really difficult to work with when a parent was aging, or they saw how they behaved with someone else and they want to make sure that person does not have an ability to make a healthcare decision for them. And you can certainly incorporate those wishes in your planning as well. In the event that you are going to put a healthcare representative in place, it's important to understand that you have the ability to determine who those individuals are. But in the absence of you stating who you want to serve as your healthcare representative, Indiana law does have somewhat of a hierarchy that determines who can consent to or make decisions to healthcare on your behalf. The first person who has the authority to make a decision on your behalf is actually the person designated in your healthcare documents. Beyond that, though, the next person is going to be a spouse. And then we have a whole group of categories of relationships of people who could assist you. That includes children, it can include stepchildren, grandchildren, siblings, and so forth. The issue is that if you have more than one child, for example, there is no hierarchy among the group as to who gets to make the decision first. So we don't just say your oldest child gets to make the decision. Any child can make that decision. What can result if you don't document who you want to make those decisions is that you can have fighting among your family members and essentially have no decision maker. So I really encourage you to think a lot about the types of healthcare you do and do not wish to receive, and then whom you might wish to name, as your healthcare representative. You can list one person, you can list a backup. If you want to name more than one person to serve as your representative at the same time, just make sure you account for family dynamics, as I mentioned before. It's often a good idea to include contact information such as a phone number for your representative in the document in case of an emergency so that individual can be reached. In Indiana, we now have one primary document that is used to name a healthcare representative. We used to have lots of documents. We had healthcare powers of an attorney, we had appointments of healthcare representative, living wills, HIPAA releases. If you have those documents in place now, they are still valid. However, if you needed to update those or you were going to put a document in place for the first time, we passed a new law which fully went into effect last year, and we combined all our prior healthcare documents into one new version of the document called an Advance Directive for Healthcare. And an Advance Directive for Healthcare allows you to appoint someone to make medical decisions for you if there's ever a time when you cannot act for yourself. It again does not take away your rights to make decisions. It does cover then powers that you're giving to the individual you're naming, and that can be one individual, and you can name backups, as I mentioned before, or more than one at a time. The powers that are governed by this document, some are non-life threatening, so access to medical information, consent to surgery, choice of a doctor, hiring companions and caregivers to meet your needs, admitting you to the hospital. There's even some things that occur after death, like decisions about organ donation or whether or not an autopsy needs to be performed. And your healthcare representative actually also takes care of funeral arrangements. Your healthcare advance directive will also include provisions with regard to withholding or withdrawal of healthcare, and our current law allows you to be as specific as you would like in terms of giving someone authority to make decisions about withholding or withdrawing healthcare, and also allowing you to determine if you want resuscitation or other life-prolonging procedures under certain circumstances. So you have some authority to govern the types of care you would or would not wish to receive under certain circumstances. I do want to quickly talk about some of the issues, some I've already raised with regard to appointing agents. So I've already covered with you two of the roles that you might need to fill in your estate planning. One is an agent under a durable power of attorney for finances. Another is a healthcare representative. We will in a few minutes talk about some other roles to fill, but I would be remiss if I didn't have you consider a few things when you're considering who to name in your documents. So of course, family dynamics is a big one. I had a case just a few years ago involving a woman. I didn't do her planning. I met with family members afterwards. This was a woman who had all of her assets listed to pass by beneficiary designation at the bank and on her investments to her two children. She had transfer on death designations, and the money went outright to the children upon her death. And I'm sure she thought that was the easiest and simplest thing to do. The problem was in that circumstance, because all of the funds went outright to the two children, there were no funds left on hand to pay her final expenses or handle income tax returns. And it turns out the two daughters didn't see eye to eye or get along, and one refused to contribute funds back to pay for things like final funeral expenses and income taxes. So I always encourage people, think about how your children get along or how other family members you may be designating actually get along, and determine how that dynamic may play out when you're naming people to serve in certain roles. Another thing to consider when you're dealing with a choice of an agent is the geographic location of that agent. It's less important these days due to electronic arrangements for someone you name as an agent or a healthcare representative to be in the state of Indiana, but you may need to make sure that they do have the ability to travel here in the event of an emergency or if they need to get added to your accounts. It will be a lot more difficult if you wanted to consider naming somebody who lived overseas or who was not nearby to serve in a role. So definitely think about how geographic location might play into the situation. You also want to consider the financial capability of the person that you are naming. Some people might be great at healthcare decisions. Others might be good at handling finances. If you're lucky, they might be able to serve in both roles. But be honest with yourself about the financial capabilities and the wherewithal of the individual you're naming to get tasks done. Not everybody is task-oriented and has the ability to follow through on things, but these types of roles really require that skill set. So you want to make sure that you're considering naming someone who's actually going to be able to get the job done. Time commitments on the person that you are considering naming are also an important and relevant factor. So, for example, I met with a client and she has 3 children and 2 of them are physicians. And while the physicians are very capable of making the decisions that she wanted to put in place, their schedules are so crazy that they really don't have the time available to serve in those roles. And as a result, she chose to name other people because she knew that they would not have the time available in order to take care of the tasks that needed to be done. You also want to consider the ability to make healthcare decisions. Not everybody is really comfortable making end of life decisions for someone or serving as a healthcare representative. So be honest with yourself and those that you're considering naming about whether or not they're capable of handling the situations that you are going to be putting them in as a result of naming them in a specific role. The last thing I've put on here is make sure you think about naming a family member if they're going to be required to oversee things for another family member for an extended period of time. So if, for example, you have one child who has special needs or who is not financially capable of managing money, it may not be a great thing long term to have a sibling oversee funds for their benefit because that might cause strife or friction in their relationship. And there are other alternatives that certainly can be discussed that might be a better choice. So, those are some things to consider as we discuss appropriate agents that you might appoint in your planning. We've talked a little bit about planning for disability. I want to talk next about making sure we cover how assets are going to be distributed at the time of your death. So this is what we call after death planning. The issues to consider in this are similar to some of what we've raised, but there are also other things for you to consider. So planning has to be completed overall to ensure the prompt and efficient distribution of your assets. How we go about doing that is going to be dependent on the types of assets you own. So sometimes you already have estate planning in place because you have a retirement plan or an insurance policy and it's going to pass by beneficiary designation. Other times, though, you have to construct the mechanism for how things are going to pass, either by adding a beneficiary designation or putting a will or some type of trust together. We need to make sure, though, that we've properly accounted for how you want things distributed and then ensure that your assets are actually coordinated with that planning so that things pass in the way you anticipate. So, as with lifetime planning, there are important things for you to consider with regard to how you're leaving money to beneficiaries. So, again, family dynamics is something that I have to deal with on a regular basis, but that you should consider as well when you're determining how to leave money among your family members. Financial capabilities of beneficiaries, again, is an issue. You may have a situation where it doesn't make sense to give someone their inheritance in a lump sum. Maybe they have a dependency issue. Maybe they've never been good at managing money. Maybe they're in the midst of a divorce or they've been sued by a creditor, or they're just going to need someone to manage the funds for them long term. There are ways to account for this in your planning. Perhaps you want to leave money to somebody who has special needs and is on means-tested government benefits. Leaving them an inheritance outright could potentially make the eligibility for their benefits go away. So there are means for us to use to make sure that the individual can receive the benefit of an inheritance while continuing to qualify for governmental benefits. Protecting assets for minor children is also something to consider, or maybe minor grandchildren. One of the things that I see on a daily basis is I meet with couples and they'll tell me that they want to make sure things are not distributed to their minor children, but they have their minor children listed as the secondary beneficiaries on their insurance policies and retirement plans. So we definitely don't want to do that, because if you do that and you're leaving money to someone who's under the age of 18, the funds are going to have to go into a guardianship account in the county where the child lives. And then you're going to have to go to court to request access to the funds. And then when the child is 18, the funds would be turned over to him or her. I have 3 kids. I have one that's 19, one that's 21, and one almost 17, and I would not want to put a large sum of money in any of their hands. So I don't recommend 18 as a particularly good age for distribution. One of the biggest concerns that I hear from clients these days is protecting inheritances in case of a beneficiary's divorce. So that is also something that can be taken into account. So what tools are at our disposal in order to plan for the distribution of assets after death? Certainly the most common one that you hear about are wills. A will is essentially a document that directs how you want your assets to be distributed at the time of your death. The person in charge of making that distribution is known as a personal representative or an executor. Executor is the Latin term for it. There are two types of assets that are going to be governed under a will. One is tangible personal property, which is the stuff you own. Another is your residuary estate. So tangible personal property are things like jewelry, clothing, furnishings, vehicles. Your residuary estate is things like your house, bank accounts, brokerage accounts, stocks and bonds. Those are going to be handled in two different categories. In Indiana, one of the things that is nice is that our state actually allows you to be specific about tangible personal property on a writing separate from your will. So if you have anything you want to specifically designate to a child or another family member or even a friend, a particular piece of jewelry or a furniture item, this document, our law would allow you to leave a separate document that describes the item and also allows you to leave next to it who you wish to receive that item. And I strongly recommend clients consider who they might want to receive their personal possessions, especially specific distributions that they wish to make. I will tell you, after 25 years, it is a misconception a lot of the time that parents have that kids want nothing of their possessions. Oftentimes, people have sentimental attachments to things you cannot imagine. So you want to make sure that you have thought through who you want to receive your possessions in case somebody does have a sentimental attachment to things. It's great to have a conversation ahead of time with your family members so that if you determine that more than one person is interested in the same object, you can deal with those issues ahead of time. Because if you haven't documented it ahead of time, what can often result is friction among your heirs. And if you're no longer living to help work through that friction, it could result in a lifetime of those individuals no longer talking to each other. I just recently had a 9.5 hour mediation fighting over the contents of a house. So I would definitely recommend avoiding that whenever possible. Wills, just so you know, do not take effect until death. At the time you pass away, wills actually are going to be required to go through a court process known as probate. So probate, wills are actually a court order directing the distribution of your estate. And probate is the process of activating the authority of the person you named as your executor or personal representative so that they have the ability to collect assets that are still in your name and make distribution in accordance with your document. In Indiana, probate is all now handled online. We don't have to go to court in order to open an estate, but it is still a public process. So people can go online and see if an estate has been opened and sometimes see what a will says in terms of how things are to be distributed. And sometimes that is not a process that people want to go through as a result. But it is much less burdensome than it used to be when I first started to practice law because we don't go open an estate in person. We don't have to get inheritance tax waivers anymore, which we'll discuss more in a bit. So it is a much smoother and quicker process than it used to be, but oftentimes people still would like to avoid the need to go through court. So an alternative to a will, and that would help avoid a court process, is a trust. So the most common type of trust is a revocable trust. That's typically what you would have as a good basic estate planning document. A revocable trust is very similar to a will. It allows you to name who you want to receive assets. You can determine how you want those assets to be distributed in the trust, just the same as you can in a will. You can direct assets to be managed on someone else's behalf. You can determine at what age or time period you want funds distributed, and you can name someone to be in charge of that distribution. The biggest difference between a will and a trust is that if appropriately funded, meaning if you retitle your assets from your name to the trust name, then there is no need to go through a court process at the time that you pass away. And that is because the trust document itself gives someone, the person's name is the trustee, the authority to collect assets and make distribution so that an order from a court is not required. So the trust document itself, if assets are titled to it, will control to determine who has authority to act. A trust can be particularly beneficial if you are in a situation where you don't want anything to be public record. Maybe you're not providing for everybody equally, or you have an estranged relationship with a family member, or you just don't want any information about your estate to be public. It's particularly beneficial if you happen to own real estate in more than one state. So let's say you own a home here in Indiana and you own a home down in Florida. Your home in Indiana is going to have to go through a court process in Indiana if it's still in your name, and your home in Florida is going to have to go through a court process in Florida, which means multiplied expense and delay because you're going to have two different probate estates. If, however, you have a trust, the trust is good in all 50 states, and as long as the real estate, no matter where it's located, is titled in the trust name, the trustee is going to have authority to collect the property or even sell it without needing to open a probate estate in either geographic location. There are a number of things to consider if you are going to put together a trust. So I've put up here on this slide some different trusts that you might consider if you were handling things for beneficiaries. One type of trust, these are all provisions you can put within a revocable trust. There are other types of trusts called irrevocable we're going to get to in a few minutes. But there are a number of things that you can address in both wills and trusts and that you should take into consideration. So one possibility is a spendthrift trust. So maybe you have an individual that you would like to leave money to who has an IRS debt or is not good at managing money or potentially has another creditor after him or her or might be going through a divorce. You can actually have a spendthrift trust, which just means that the money is going to be held in trust and managed by someone else and doled out for the beneficiary's needs. But since the beneficiary doesn't control the funds himself or herself, the funds are actually protected from lawsuits or creditors. A special needs trust is a provision that allows an individual to set up funds for the benefit of an individual who may be disabled or have a special need. And it ensures that the beneficiary can receive the benefit of funds which are being inherited, but the funds being inherited are not counted as a resource in case the individual receives something like Medicaid or SSI, which is means tested and is subject to an income and resource limit. Sometimes you might have a situation where you're planning for minors, like young children or young grandchildren, and you want to make sure that money can be held for their benefit until they reach a certain age or ages. Just so you know, I don't usually recommend that individuals leave money to children outright prior to age 25. That's my rule of thumb. I've been told by many doctors that supposedly 25 is when the brain stops developing, but you don't have to leave it all to them at 25. You can pick different ages or different goals for them to attain before they receive funds. You can also hold it in one pot to be used for multiple children's needs if, for example, you have young children and you're trying to raise them to a specific point in time before dividing up the assets. Another thing to consider for both trusts and wills is the choice of fiduciary. Who are you going to put in charge? Who is going to be best able to collect assets and manage it long-term for the benefit of your beneficiaries? Sometimes that's a family member if you have someone who is capable of doing that and there is not friction that's going to result as that person is appointed. Sometimes you may need to consider an alternative like a third party. There are banks and trust companies that exist who can work with your family members and oversee distributions long term, but you can not have a family member necessarily serve in that position to avoid some of the friction that might otherwise result. I didn't put it up here, but you can even use a third-party trustee and still have someone serve as what we call a trust protector. So sometimes I have people who want family members to still be involved, but they do not necessarily want that individual to have to be the person to say yes or no to distributions. So a trust protector is a separate role that allows a family member to give guidance to a third-party trustee when they're making discretionary distributions or handling things on behalf of a beneficiary. And that trust protector can be given certain roles, even the ability to change the trustee if necessary. So those are terms that can be included in your documentation. We're going to talk a little bit about estate taxes next. We are actually in a state of flux here in the US. Currently, we are in the midst of a U.S. estate tax law that went into effect in 2017, but is set to actually go away the end of next year unless Congress takes action. You're probably not shocked to hear that any sort of estate tax exemption is tied to our budget. And as a result, there really are no permanent laws with regard to taxation. The laws simply last for a period of time, and then periodically they're changed or they sunset as a result. So currently in the United States, the federal gift and estate tax exemption, the amount we can either give away during our lifetime or pass at our deaths, is at the highest level it's ever been. It's currently $13.61 million. If an individual dies, and so let me back up for a minute and say it's $13.61 million per person. That means if you are married, a couple can currently pass over $27 million free of estate tax under current US law. To give you an idea of how much change I've experienced in the course of my career, when I first started practicing law, the estate tax exemption was $600,000. So it's changed a lot in the 25 years. If an individual or a couple has assets in his or her estate which exceed the exemption amount, the tax is going to begin at 29% currently and go up to 40%. 40% is the current top tax rate under our gift and estate tax rate. Next year, the amount of the federal gift and estate tax exemption is going to go up again. We're currently subject in this law to an inflation adjustment. So it'll go up again next year, could be closer to 14 million. However, the law is set to sunset at the very end on December 31st, 2025. And if Congress has not taken action, then on January 1st, 2026, the exemption amount is essentially going to be cut in half, and it'll fall back to $5 million with an inflation adjustment. So we anticipate it being right at around $7 million in 2026 if Congress does not take action. I wish I had a crystal ball and could tell you what the idea is going to be with regard to the estate tax, but I don't have a crystal ball, and I can tell you for sure that we're not going to have any clarification on this issue until at least past the next election. However, I think it's highly likely, from what I'm hearing from the people that I know in Washington, that Congress will allow it to sunset, because at the high level that it's been at, it still impacts less than 1% of the population, even if it falls back to $7 million per person. I wanted to also point out, we used to, when I started practicing law, have a state level of death tax known as the Indiana inheritance tax. We also got rid of that. That expired in 2013. We did away with it as a state. So currently, when you pass away, if you're under the federal estate tax exemption, you will not also have to worry about any sort of state tax, because we don't have inheritance tax in the state of Indiana. If you become a resident of another state, you should be aware there are about 15 states, might be 16 now, that do still have some state level of death tax. Most of them are on the coasts, and some of them do not have exemption amounts that are very high. For example, Washington State has a $2 million exemption from state inheritance tax. So you want to be aware that it is a possibility that if you own assets elsewhere or you become a resident of another state, that you could have a state level of death tax, which does not in any way hold, is not tied in any way to the federal estate tax exemption. But if you're an Indiana resident, there is no inheritance tax in this state. One of the things that I wanted to cover with people while we're having this presentation is making sure the tax planning provisions in your estate planning documents are current. So it is not uncommon for me to review documents that were put in place 20 years ago by clients. They may have existing revocable trusts. And 20 years ago, the estate tax exemption was much, much lower than it is now. It was about $1 million per person. Commonly, the way we did planning back then was to make sure there were assets in both spouses' names, and typically people would put in place a trust for the husband and a trust for the wife. And then in the event that one spouse passed away, instead of the assets automatically flowing to the other spouse, instead the assets of the first spouse to die would flow into a credit shelter trust. And that is because under IRS rules, if you die and you leave assets to your spouse, the IRS says, that's great, you're just passing money between spouses, and that is considered to be a tax-free transfer. If, however, the surviving spouse has all the assets in his or her name and they exceed one exemption, then the tax kicks in at 29 to 40%. So for years, what people did was they set up credit shelter trusts so that they could use one exemption when the first spouse died and then a second exemption when the second spouse died. What has happened over the years is that as the estate tax exemption has risen, some of the need for that type of planning has gone away. So I always recommend that you have that provision in your estate planning reviewed because there are some negatives associated with creating a credit shelter trust if you don't really need it. So two things have happened, and well, one thing is that the exemption amount has risen. The other thing that has occurred since I originally practiced law is that in 2013 we passed a law called portability. And portability says even if you leave all the assets to your spouse and you don't set up a credit shelter trust in advance, you can still carry over the deceased spouse's unused exemption to the surviving spouse. Currently, you have 5 years to file a return to elect to carry over the unused exemption amount of the first spouse to die to the surviving spouse. Because we have portability and because the estate tax exemption has risen, if you are under one exemption, it may not make sense anymore to require the creation of a credit shelter trust in your planning. When you have a credit shelter trust in existence following one spouse's death, that's going to require that the credit shelter trust file its own tax return. It'll be held under its own tax identification number. And even more importantly, the assets are going to have their income tax basis reset to the date of death of the first spouse to die, but the basis is not reset again when the second spouse passes. So if, for example, one spouse owned a share of stock worth $10 per share at the time that they passed away, the basis would be reset at that spouse's death to $10 per share. If the surviving spouse lives another 10 years and the value of that stock increases to $100 per share, the basis is not going to be reset on that credit shelter trust, which means when ultimately it passes on to your family members, they could potentially owe capital gains tax on the difference between what the stock was worth as of the time the first spouse died and what it's worth at the time of sale. What we can do if we don't need credit shelter trust planning anymore is still use portability, but allow assets to pass to the surviving spouse. And this allows for a full step up in income tax basis on the assets at the death of the second spouse, which can result in no estate tax and also little to no capital gains tax following the death of both spouses. So it's a good idea to review those provisions and make sure they still make sense for your particular estate. We're going to talk next then about some tax planning alternatives. So many people are concerned, especially with this potential change in the law, and others may not be concerned about taxes, but they have a desire to potentially give assets to their family members now, as opposed to waiting for them until they die. So there are several laws that are in play, and the three most common ones allow you to make gifts during your lifetime. And we're going to talk about lifetime gifting next. Lifetime gifting is a great option. Many people use it to kind of keep appreciation in their asset down. In their estate down. They may want to gift assets on an annual basis to lower their estate, but also to help their kids when they want to buy a house or pay for their grandkids' school or whatever the case may be. So the three common things you should know about lifetime gifting. First of all, each of us has an amount we can give annually, which is not subject to any sort of gift taxation. That amount in 2024 is $18,000 per person. I had somebody come in the other day and they said, can you still give away $10,000 per year? You can, but $10,000 is a number it was many, many years ago. It's now $18,000 per person. So if you're married, you can give $18,000 to anyone you wish, and your spouse can give $18,000 to anyone they wish or to the same person. So $36,000 can come from a couple to one beneficiary. No taxation as a result of that. The second thing to know about gifting is that you can use your lifetime gift and estate tax exemption during your lifetime. So if you want to make a gift to a particular beneficiary which exceeds the annual exemption amount of $18,000, you can do so, and it won't necessarily result in tax being due, but what it will do is use up a portion of your lifetime gift and estate tax exemption. So for example, if you made a $100,000 gift to your daughter, $18,000 would be considered a an annual gift tax exemption, so there would be no tax on it. But the other $82,000 that was given is going to eat into a portion of your $13.61 million lifetime gift and estate tax exemption. So there is a requirement if you give more than $18,000 every year or in a year, to a particular beneficiary, that you file a gift tax return by April 15th of the next year to show how much of that lifetime gift and estate tax exemption you actually used. The other rule to be aware of is that we actually have a provision under the IRS code that allows you to make unlimited gift amounts for someone's educational or healthcare expenses. But if you want to do that, you want to help pay for someone's college or you want to help pay for large medical bills, the distribution has to be made entirely either to an educational institution or to a medical provider. You can't give the gift to somebody and then say, hey, use this to pay for your education. You would instead have to write the check directly to a university or directly to a private school in order to assist the beneficiary or directly to a medical provider. But there is no limit on the amount you can give on that type of distribution as long as it goes directly to a provider. Lots of people are now considering, as a result of the potential change in estate tax laws, using up some of their lifetime gift tax exemption, gift and estate tax exemption during their lifetime in order to help reduce their estate in case the estate tax exemption is reduced to approximately $7 million. If I have clients with large estates who want to consider doing this, I've been telling everybody it must be done before December 31st, 2025. But really, you need to have provisions in place to get this started no later than July 1st, because oftentimes if you do want to make gifts during your lifetime to help reduce the potential taxation at your death, you might need valuations, you might need to have trust documents created, and it doesn't happen overnight. You need time to get those steps in place. So if you are considering any sort of planning due to a change in estate tax laws, make sure you get that started at least 6 months before the estate tax exemption expires. If you do not, you may find yourself in a situation where you're not going to be able to get that planning done because people who perform valuations or attorneys may be too booked and will not be able to assist you. One thing to know is that the IRS has already issued guidelines that state if you make gifts during your lifetime while the estate tax exemption is high and they exceed what the exemption amount falls to, you are not going to be penalized. So if, for example, the estate and gift tax exemption is $13.61 million this year, and you make a gift of $13.61 million, you would have no exemption left if the exemption falls to $7 million. If, however, you made a gift of $1 million while the exemption was 13.61 and the exemption falls to 7, you would be considered to have used 1 million of the 7. So you'd only have 6 left. So when people are considering doing any sort of lifetime gifting or lifetime tax planning, it really only makes sense to do so at this time as an advanced tool if you're going to do so in an amount above what the estate tax exemption is anticipated to fall to. So that means making a gift in excess of $7 million, which is not something that everyone is in a position to do. Just so you know, though, in addition to lifetime gifting, and you don't have to make those gifts outright to your children. As an example, you can do different types of trust planning. You can make gifts to charity. But there are things you can do that would not require you to make a gift quite that high if that's not something you want to do. There are a number of different strategies that can be used to help reduce estate taxation, and I've listed a few of those here. I'm not going to go into a lot of detail with regard to those different options, but I did want to let you know what each of those stands for so that if it's something you're considering or you have an interest in learning more about, you'll be aware at least of this type of planning being in existence. So one thing about estate planning is that we use a lot of acronyms, especially for types of trusts. So the first few things that you see there are 2 different types of irrevocable trusts that we use when we are concerned about gift and estate tax long term. So one is called a SLAT, that stands for Spousal Lifetime Access Trust, and one is referred to as a grant, which is referred to as a grantor retained annuity trust. A SLAT is a type of trust that you can actually set up for the benefit of your spouse that allows you to gift assets to a trust for that spouse's benefit now, which will shift those assets outside of your estates and not be subject to taxation later on. The spouse can be the trustee of that trust and can receive the benefit of the funds in that trust. But if the spouse dies, the assets in that trust flow on to your children or other beneficiaries you name and would not be available to the spouse who originally created that trust. A grantor retained annuity trust is a method that we use if people have closely held stock or other investments and they are appreciating, and we want to shift that future appreciation outside of their estates. It involves making a gift to a trust, and the trust actually returns the principal distribution to the person who created the trust over the period of the trust term, but any appreciation on that asset is actually outside of your estate and would not be subject to tax. There are also other things you can do, like family limited partnerships or family LLCs, to allow you to pass down closely held businesses or potentially keep control with one generation while you shift the value of assets to another. Another commonly used vehicle for estate purposes is something known as an ILIT. That is an irrevocable life insurance trust. Many people will consider getting life insurance to provide liquidity to help cover things like estate taxes in the event of their passing. An irrevocable life insurance trust allows for the policy to be owned by a separate trust so that when the individual passes away, the proceeds from that policy are available to pay tax, and the policy proceeds themselves are not taxed. If, for example, an individual takes out, say, a $3 million policy to cover estate taxes, but they're still the owner of that policy, the $3 million benefit payable on their death is actually going to count towards their estate tax exemption. So that's $3 million that's going to be added to the other assets in their estate. And if they exceed the exemption amount, tax will begin at 29% and go to 40%. So an irrevocable life insurance trust allows an individual to get an insurance policy and have it be owned by a trust so that the funds are available to pay tax, but the proceeds themselves are not subject to taxation at death. Another thing people consider with regard to taxes, or maybe because they simply have a charitable intent, is to consider some form of charitable donation. There are lots and lots of ways for people to make charitable donations these days. You can do something as simple as making an annual gift to charity. You can include provisions in your estate planning to provide for distributions to charity at your death. We're going to talk about qualified plans in just a minute and how they can be used for charity. You can even use things like donor advised funds, which allow you to contribute either annually or at your death funds into an account. When the funds go into this account that's going to be used to fund charitable organizations, you get an income tax deduction for the money that you're putting into the account, but there is a requirement that those funds then be used for charitable organizations. There are also charitable trusts that allow you to leave money to charities. They can even provide income to you for your lifetime, and even family foundations in case you want to benefit charity, but you want to encourage the involvement of family members to help run those foundations and ensure a legacy of giving. So there are lots of opportunities. Just so you know, any money you leave to charity does not count toward your estate tax exemption. So you have 13.61 million plus an unlimited amount of money you can leave to charity, which is not subject to tax. I also wanted to quickly touch on qualified plans. I have to say that when I review assets with my clients, most people have a lot of wealth involved in qualified plans, and those typically are tax-deferred retirement accounts like 401ks, 403bs, IRAs, KEO plans, SEPs. They are currently the largest source of wealth in the United States. In fact, there's $55 trillion in retirement plans alone in the United States. If you are a participant, the person contributing to the investment in a retirement plan, you are not required to take a distribution from the retirement account until currently you're age 73. That's going up to age 75 over the next few years. If you die and you leave the asset to your spouse, the spouse is also not required to take a distribution from a retirement plan until he or she is 73. If you leave retirement accounts, though, to your children or your grandchildren, they are going to be required to take distributions from your retirement account out, and they only have 10 tax years to take out the full value of the account, and the amount they withdraw is subject to income taxation. As a result, if I have clients who have a charitable intent, one of the things that I often recommend they do is consider making charitable distributions from a portion of their qualified plans. And that is because the charity will not pay income tax at the time the funds are distributed to the charity, whereas your children would be required to pay income tax on those sums. So that's a way to allow you to meet your charitable goals while also ensuring that your children receive as much of an asset from you that is not subject to any sort of taxation. I know I've covered a lot of things over the course of the last few minutes. I wanted to put in place just some next steps that I recommend that people do with regard to estate planning. So number one, of course, is take some time to put a comprehensive plan in place that covers both disability and death. But also make sure you have your plan reviewed. In my office, we like to meet with clients at least once every 5 years for a free review meeting. We can meet more frequently, but regardless of who you use, it is a good idea to make sure you pull that out and review it periodically, because oftentimes people have changes in their family members or the makeup of their assets or family dynamics, which could potentially result in a need for a change. You also want to make sure your assets remain coordinated with your planning. So make sure your attorney and your advisors work together to ensure the proper coordination between the assets and the documents that you wrote. And then finally, make sure your family knows you have a plan and where it can be found so that in the event of an incapacity or a death, they have the documents they need in order to best assist you. All right. I think we're going to turn now to our questions. So what I'm going to do is stop sharing my screen, but I will also make sure that the information in these slides is available through Evans May. So if you want any of the information that I've provided today, it'll be accessible to you.
Thank you so much, Rebecca. Lots of information. So we appreciate it very much. We did have a few questions.
Sure.
And so going back to probate, you did share a little bit on that. Can you revisit that at a high level? What is probate? And then thinking through when assets have a transfer on death, legend, or named beneficiaries, are you avoiding probate altogether, or how does that work?
Yes. So probate is a court process in which if you have a will or you don't have a will, you can have probate whether you have a will or you don't. If a person passes away in the state of Indiana and they have assets in their individual name, so not joint, not passing by beneficiary designation, individually held, and the value of those assets exceeds $100,000, then in order to give someone authority to collect those assets and make distribution, we have to go through a court process called probate. Probate is just a reporting to the court in the county where the individual resides or owns property to indicate that that person is now deceased, and we need to activate the authority of the personal representative or someone else to be appointed as a personal representative so they can collect that asset and make distribution, either in accordance with the will or in accordance with Indiana statute if they died without a will. As I mentioned before, probate is all done electronically here. So we prepare documentation to indicate when someone passed away. We then file it electronically, and about 48 hours after that's filed, the court will come back and issue what's called letters of administration or letters testamentary. And that's the calling card, if you will, that shows that now someone has authority to go to a bank or another financial institution or to sell a house that was in the deceased individual's name. In order to act then, they need those letters, they're going to need a death certificate, and they're going to need a separate tax identification number for the estate, which allows them then to collect assets and make distribution. If you have an asset in a trust or you have an asset that is going to pass by payable on death or transfer on death designation, that is going to avoid the need to go through any sort of court process to collect the asset. If you have a payable on death or transfer on death designation on an account, then typically a death certificate has to be provided and a claim form has to be completed to allow you to collect the assets, but you don't need an order from a court or letters from a court in order to collect the asset. Sometimes that is the appropriate way to go about leaving assets. Sometimes it's not. You do want to think through how you leave things and who is going to be a beneficiary. I mentioned one of the stories that I had to deal with where I had these two sisters who were left as beneficiaries on everything and they didn't get along, and then one wouldn't contribute back to pay final expenses. So those are kind of the things that we consider when we determine the best way to leave assets at passing. There are lots of different ways to do it. You want to just make sure what you choose is right for your particular family situation.
Wonderful. Thank you. Another question that has come in is related to protecting assets in the event of an illness. So how can a trust protect you or your spouse from high medical expenses in the case of illness?
Sure. So I didn't get into a lot of discussion about long-term care planning, but that is the other side of my practice. So many people are concerned about the high costs of long-term care. When we're talking about preserving assets for one spouse in case the other needs care, we're typically talking about complying with a type of rules that are actually called Medicaid rules, because if you're not privately paying for care and you don't have long-term care insurance, the only way that care is going to be paid for is through a governmental program called Medicaid, which is funded through federal and state tax dollars. There are a few things to be aware. First of all, if one spouse needs care and the other spouse does not, there are certain rules which automatically exist which protect some assets for the spouse not in need of care. The home, for example, is protected. In Indiana, any other real estate like a lake house or rental property that's in the other spouse's name, the one not in need of care, is exempt. A vehicle of any value is an exempt resource. Currently, but may change soon, retirement accounts in the name of the spouse not in need of care are exempt. And then a certain amount of other assets is automatically protected for the benefit of the spouse not in need of care. But that taps out at $154,140 this year. So it's not a huge amount. Sometimes people will come to me and they want to pre-plan because they're concerned about the cost of long-term care. And there are a number of different things that we can do for pre-planning. One of the common ones is to use a different type of trust called an irrevocable trust, which allows you to transfer assets into the trust. And 5 years after those assets are put in trust, they are protected in case one or both spouses needs long-term care. An irrevocable trust is not a type of planning you're going to use for all of your assets because there is a loss of control associated with it. The person who is creating the trust cannot be the trustee. So you're always going to want to have some assets outside of that trust, but it is one tool in the toolbox that helps us protect in case of the need for long-term care. There are some other things that we can do with regard to real estate, prepaid funeral arrangements, and other initiatives that we can do with regard to long-term care planning, but an irrevocable trust is the biggie.
And just to follow on that, for the long-term care planning, is there a best time to come and see you if you're interested in pre-planning?
So I usually follow a rule of thumb. If you're still paying for kids in college or paying for kids in preschool for sure, you're probably too young to be concerned about long-term care. Typically, the sweet spot is usually between the ages of 55 and 65 was when we're going to do the most pre-planning for long-term care. We will look at things in conjunction with individual advisors about long-term care insurance and other initiatives to pay for long-term care. But we can also consider doing some pre-planning with regard to trusts or changing of deeds and other things that might help accomplish the protection of assets in case care becomes a reality.
Okay, wonderful. Well, we will finish the questions there. So Rebecca, on behalf of Evans May Wealth and our clients, thank you so much for your time and valuable insights. As Rebecca mentioned, we will have the information that she shared today here at Evans May Wealth. So if you guys want to revisit that, we also have this recorded to be revisited as well. There's so much to know. We definitely appreciate you sharing your expertise. And we know that this affects all of us at some point in our lives. So to all of those that have joined today, we hope you found a lot of value in Rebecca's insights, and we look forward to continuing the conversation with you in future meetings. So thank you, Rebecca. Thank you, everyone who joined us, and have a great evening.
You too.
Thank you.
Thank you.